Hey everybody, welcome to the Credit Repair Experts. Today we're actually going to be talking about a pretty controversial topic. So, pretty much what we're going to be discussing is basically like, is it okay for a debt collector to reach out to you, period?
Right.
We're going to be talking about some of the stipulations that are kind of involved with debt collectors reaching out to you, and we'll open it up at the end for y'all to be able to ask any questions down in the comments. So if y'all want to know anything extra that we didn't talk about today, then leave us a comment. But with no further ado, let's go ahead and dive into it.
Thanks, Jesse. So today we're going to be going over something called the Consumer Credit Protection and Debt Collection Practices Act. So this was passed by Congress, and it's codified in Title 15 of U.S. Code 1692. So this one lays out exactly what a debt collector is and what it is they can and cannot do when it comes to your credit. So a lot of people don't know that actually it's against U.S. code, it's against the law for them to actually communicate with you in connection with a debt unless you give them express permission and consent to do so. So I'm going to go ahead and cite for you guys a portion of this code, and then we're going to go over it. So this is 15 USC 1692 subsection C, communication in connection with a debt. Without the prior consent of the consumer given directly to the debt collector or the express permission of a court of competent jurisdiction, a debt collector may not communicate with the consumer in connection with the collection of any debt. Number one, at any unusual time or place, or a time or place known or which should be known to be inconvenient to the consumer. Now, when is a usual time or place that you receive communication with a debt collector? The answer is none. There is no usual time that you anticipate to be contacted by debt collectors, whether that be your original creditor or a third party agency like a collection agency. Both of those are codified as debt collectors in the definition section of this title. So they cannot contact you at any time or place without your express consent. This is very important. But they shall assume that the convenient time for communicating with the consumer is after 8 a.m. and before 9 p.m. Okay? So they'll assume this, and they can make this assumption because they have not been notified that you're aware of this fact. You have to actually tell the debt collector that trying to communicate with them in connection with the debt is a violation of 15 USC 1692. So we'll keep going in this. If the debt collector knows the consumer is represented by an attorney with respect to such debt and has knowledge of or can readily ascertain such attorney's name and address. So if you have to hire an attorney for like bankruptcy or something, they'll try to find that information. Or number three, at the consumer's place of employment, if the debt collector knows or has reason to know that a consumer's employer prohibits the consumer from receiving such communication. So they can't even contact you at your place of employment. And I know many of y'all out there may be suffering from that. You may have a debt collector calling your employer asking to talk to you and trying to set up with you some sort of payment plan by garnishing your wages. This is totally against code. So what you need to do is you have to notify these people with a cease and desist letter, and you have to tell them that this is in violation of U.S. Code 1692. And that's where we come in. We actually help professionally lay out for you a written notice so that you can actually get these people off your back. Because it doesn't matter how much you call them, it doesn't matter what you say. They're just going to try to railroad you. But when you send a written notice, because it's on record, that's when they respect it. Because at the end of this section, at the end of this section of code, it actually says that for every violation of this code, it's a $500 to $1,000 fine per violation. So all you got to do is go through your call log, and you can see how many times they call you, and every time that's $500 a pop, and you can sue them in small claims. So that's just one of the sections of the U.S. Code that I wanted to go over today. We're going to go over this entire chapter together, piece by piece, later in the future. But I want y'all to get that in your mind that debt collectors, whether they're your original creditor or a third party agency, are not allowed to contact you by law. So don't let these people railroad you. Okay.
Yeah, exactly. And another thing that I would like to remind everybody is whenever you are communicating with these agencies, it is best to do it through letters, like Brennan was just talking about. But something else that you really want to try to keep in mind is every single time you send them a letter, you want to make sure that you're sending it certified mail. And the reason that you want to do this is because if you send it certified, then you'll know for a fact that they received it. There can be no question. So if it does have to go to a small claims court or any other type of court, it's documented that they received your notices and they'll have no excuse. There will be no wiggle room. So, take no hostages and leave no prisoners.
Yeah, dude. They're going at you using fear and coercion to try to get you to pay. So, just let them get scared, man. They hate these letters.
Exactly. And this will be the first process of repairing your credit, getting the creditors off of your back. So I hope that this helps you guys out, and we look forward to talking with you guys later. And if you guys want to see any additional content and you have any ideas of something that you would like to see, again, just leave us comments down below.
Thank you very much.